All right, welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Jerry Brown.
Here.
Kirkland Huggins. Max Juarez. Ian Gray. Mr. Gray, your attorney is ill. I'll call you up here in a moment. We'll get you reset, okay? Lloyd Hallbrook.
Here.
Thank you, Mr. Crawford. Shiloh Scott.
Present with counsel.
Thank you, Mr. Harrison. Jonathan Daniel.
Here.
Alan Shelonburgger.
Present with counsel, Your Honor.
Thank you, Mr. Schmidt. Daniel Admire.
Here.
Courtney Atwood. Linda Bennett. Wyatt Berkland, cause number CR 24128. Mr. Schmidt, he's been verified in custody in the Kyle unit, so we'll recall that case and set that. Trevion Bowie. Mr. Bowie is in cause number CR 24-198, verified in Smith County. We'll recall that case. Roger Bridges.
Here.
Carissa Coleman. Ms. Coleman is appearing via Zoom today with court's permission, and she is present in the Zoom waiting room. Shanta Foster is verified in custody in Gregg County. We'll recall that case. Trevor Glover, cause number CR 25-8. Court's received some kind of notification that there's some medical issues. I'll recall that case. Fernando Hernandez.
Here.
Ashley Holleshauser. Benjamin Carnes. Benjamin Colin Carnes. Reno Moreno. Anthony Murray. Anthony Wayne Murray. Stephen Richardson.
Here.
Michael Rodenball. Jennifer Schaefer. We'll recall that. Edgar Vasquez. Edgar Ariel Vasquez. Pascal Waters. Pascal Todd Waters. Ray Anthony Williams. Court will recall that case as well. Cedric Thompson. Court finds that Mr. Thompson is currently in the Veterans Affairs Hospital. Court has reset pretrial, I think, on the agreement of the state to July 8th. That's cause number CR 25-19. Karen Kirby. And Ms. Kirby, you're probably aware, but your attorney is in trial in Navarro County. And so I will call you up shortly and we'll get you to sign a reset. You'll be free to go. Larry Stanford. Larry Charles Stanford. Mr. Stanford is also represented by Mr. Weiner. Mr. Weiner is at trial in Navarro County, but Mr. Stanford was ordered to appear, sign a notice of reset, and check in with the pretrial release officer. Chrissy Kaiser. Jose Salazar. Lemmy Brandon. Joshua Brown. That's Zachary Culie.
Present, Your Honor.
Carrie Criswell.
I've got this table setting states of this Mr. Criswell passed away this week. He actually came forward, checked in probation.
Do we have a date on that? For docket call. All right, record reflects cause number CR 24-301, State versus Carrie Lynn Criswell's reset by agreement, docket call July 1st. James Fontenot. Joshua Huffman, Kimberly King, Kimberly Madeline King, Arnold Kinsey, and Philip Swallows. Philip Wayne Swallows.
Your Honor.
All I have is pretrial notice that he's failed to appear in April. To anyone in the courtroom, you've not heard your name called? Do we have any attorneys that are ready? Harrison, you ready?
Miss Scott, Your Honor.
Ms. Scott, if you'll come forward. This is cause number CR 24-225, State of Texas versus Shiloh Darnell Scott. We're set for docket call. Go ahead, Mr. Harrison.
Your Honor, I'm going to ask for one more reset. Last time we were here, we believed after going through the discovery, there was additional documentation we needed. We asked for it. Apparently that does not exist. So I think discovery has been completed and we have everything. However, from the discovery, there've been multiple individuals we've located and begun trying to interview. There's still a couple we've got outstanding. I want to get that information to Ms. Curry, despite the fact she said she's given us her best and final offer. If that doesn't move the needle, then we'll probably just ask for a trial setting next time.
State.
That's correct, Your Honor. We have made best and final offer. It's Mr. Harrison. It's just notified the court. So that's our position.
Is there any objection to his request for one additional docket call?
Yes, if he is communicating with Miss Curry, I obviously don't know the extent or at what point those communications were left. So
She neither agreed nor disagreed. I didn't actually ask her about her position on pass. We have been talking about the case. She knows I've been trying to get her some additional information. I just don't have it yet.
maybe with quick resetting, Your Honor, I guess, as a compromise.
How long are you asking for, Mr. Harrison?
Judge, looking at our calendar, I think you've got a setting on June 1st. We'd be happy with that.
Got June 10th or 12th. I think first is a Sunday.
Oh.
Be roughly 2 weeks. We're in trial next week.
I'm sorry. I meant July 1st.
All right, court will grant Miss Shiloh Miss Shiloh Miss Scott, one final docket call to July 1st. And on that date, we'll either announce a resolution or a request for a trial.
Yes, sir.
All right, once she signs her notice, she's free to go. Mr. Shelonburgger, if you'll start making your way forward. Alan Shelonburgger, cause number CR 25-85.
Morning, Your Honor.
Morning, Mr. Schmidt. All right, this is set for pretrial today, cause number CR 25-85. Go ahead, Mr. Schmidt.
Your Honor, we have no contested pretrial. If we could just set this for a docket call, I will be here on July 8th if that's possible.
July 8th.
Yes, sir.
And has your client signed the conditions of the court's pretrial release? No.
Are you on pretrial or you said when?
Have you met with court's pretrial release?
No, he's supposed to bail, Your Honor. But I know Mr. West was in here.
It's probably outside. So, Mr. Shelonburgger, before you leave, you'll need to meet with the court's pretrial release officer, Mr. West, and sign the conditions of pretrial release. Mr. Schmidt can answer any questions if you have it on those. Okay. Court recess, Mr. Shelonburgger, then to Tuesday, July 8th for docket call.
Thank you, Judge. May he step back and we'll talk to Mr. West?
Yes.
Thank
Yeah,
you.
once he signs, he's free to go.
Thank you. My big shoes is on.
Yes. Mr. Crawford, you ready?
Yes, Your Honor. Place the paperwork right there in front of the basket.
Lloyd Hallbrook,
Yes, Your Honor, he's here.
this is cause number CR 24-209. Mr. Hallbrook is set for docket call. Go ahead, Mr. Crawford.
We want to set it for jury trial, Judge.
Okay, have you and the state reached the final negotiations and none will be had regarding a plea agreement?
Yes, Your Honor.
All right, what was the offer that was made to Mr. Hallbrook so we can note that for the record?
Your Honor, it was for 8 years deferred probation and then some special conditions of probation.
And is that to the indicted charge, injury to elderly, child, disabled, whatever that may be?
Yes, Your Honor.
All right, and Mr. Crawford, your client understands that the court may not allow him to engage in plea negotiations after today.
Yes, Your Honor.
All right, the court will set Mr. Hallbrook then for jury selection beginning through June 23rd. So Mr. Hallbrook, on June 23rd, your case may not be reached for trial. If it's not, then you'll just stay downstairs. You'll meet with my court staff. They'll have you check in with a pretrial release officer, sign a notice of reset, and you'll be free to go. Okay, but don't come up in here because we may be trying a different case at that time. All right, stay in contact with Mr. Crawford. He'll advise you as well. All right,
Thank you, Your Honor.
thank you, Mr. Crawford. Good to see you.
May I be excused?
Yes, sir. Mr. White. Who would you like first, Mr. White?
We'll just go in alphabetical order. Kaiser.
Chrissy, Kaiser, CR 25-47. Remind me, is it Kaiser or Kaiser?
Kaiser.
Kaiser, that's what I thought. All right, Ms. Kaiser is set for pretrial today. Go ahead, Mr. White.
Your Honor, I don't have any contested pre-trial. I spoke with Ms. Curry last week. Due to the voluminous amount of discovery on this, she agreed that we could have one more pre-trial for me to get a chance to go through everything one more time.
Any objections from the state?
No objection, Your Honor. Thank you.
All right, court will reset Ms. Kaiser for an additional pretrial or let's just go ahead and set it for docket call. And we'll set that. July 1st, Mr. White.
That sounds fine, Your
All
Honor.
right, court sets Ms. Kaiser for docket call July 1st. At 9 a.m. Once she signs her notice, she's free to go.
Okay.
Do we have any other attorneys in the courtroom that are ready? Not seeing any. Mr. White, are you ready on your other client?
Yes, sure.
Jose Salazar. This is cause number CR 25-84, State versus Jose Manuel Salazar. And we are set for pretrial today, Mr. White.
Yes, Your Honor. I don't believe that there is any contested pretrial on this matter. However, I have spoke with the state about being able to get some additional discovery, specifically the prior conviction that raises this up to a felony on the family violence. I don't have any access to that, and it's out of, I believe, Dallas County. And I believe they said that they would get that to me.
State.
Yes, Your Honor. We're working on getting a certified copy of the judgment.
Any objection to an additional pretrial?
No objection, Your Honor.
All right, court sets Mr. Salazar for an additional pretrial hearing on July 1st. 9 a.m. Once he signs, he's free to go. Is that all you have, Mr. White?
Please, so, Your Honor.
Oh, Mr. White, I think Ms. Tabringham wants to talk with you. Oh, yeah, okay. Sure. She's on page 7.
Here now. Okay, so that's.
So, Mr. White, it's my understanding that on Miss Jennifer Diane Schaefer, you're willing to accept an appointment from the court.
Yes, Your Honor.
All right, so she is not here today. Court finds that Mr. Richard Schmidt has a conflict, has filed a motion to withdraw. The court grants its motion to withdraw. Court will substitute Mr. Jeff White as counsel. She has notified the court that she is ill today with flu and strep. So we're going to reset her for July 1st. For pretrial. Give you time to get the discovery from the state.
My apologies, Your Honor. I was having a side conversation with Mr. White. What name did we call?
This is Jennifer Schaefer, cause number CR 25-24. Mr. Richard Schmidt was representing Ms. Schaefer, and he discovered a conflict, filed a motion to withdraw. Court's granted that. And Mr. Jeff White has been kind enough to accept an appointment to the court.
Thank you, Your Honor.
To cover that conflict.
I
We're gonna set it
appreciate it.
July 1st. And she's out today due to flu and strep.
Okay.
Mr. Huggins. All right, this is a sanctions court hearing, cause number CR 20-125, state of Texas versus Kirkland Huggins. Mr. Huggins, this is your first time in Commissioner's Court, correct?
Yes.
I'm sorry, in sanctions court.
Yes,
Got its own kind of sanctions, Commissioner's Court. And so, Mr. Huggins, you were placed on deferred probation in this court December of 2020, is that correct?
Yes, sir.
For 10 years.
Yes, sir.
And it's deferred, meaning you've not been convicted of the offense of robbery, is that correct?
Yes, sir.
And you understand that if you violate the terms and conditions of your community supervision, and that's proven to the court through a hearing, that the court could revoke your community supervision and convict you and sentence you to prison anywhere from minimum 2 years up to a maximum 20 years, I believe. Actually, if it's a first degree, it's minimum 5 years up to a maximum of 99 years of life. You understand that?
Yes, sir.
So you're in sanctions court today because the probation department has indicated to this court that you've not been attending counseling as recommended from your evaluation. You're delinquent on your probation and court fees, and you're not working your community service. Is all of that true?
Yes, sir. I did actually just get some community service hours turned in. The delinquent on my probation fees, I did lose my job and I kind of had to get back onto my feet. I did end up paying about, I think it was $1,100 in March to actually get back onto getting back on the right track. And then as for the classes with Chuck, whenever I lost my job, I didn't have the money to be able to pay him to be able to do the classes. And whenever I told him that I didn't have the money, he told me I still wasn't allowed to go, even though I was required to.
What kind of work were you doing?
I'm doing welding fabrication now at the muffler shop here in Canton.
What job did you have before that you lost?
I worked at ARS Equipment in Van, Texas.
Also doing welding?
Yes, sir.
And why did you lose that job?
Me and my supervisor, we kind of had a disagreement, and then just started escalating from there, and I decided to take myself out of his position to where I would get myself in trouble instead of just walking away from it.
You understand that you need to do community service every month.
Yes, sir.
It's not we'll wait till it piles up and then do a bunch. You understand that? You understand that failure to do community service when you have the ability to could be a revocation issue.
Sir.
It'd be sad to go to prison for not working community supervision, wouldn't it?
Yes, sir.
So this is what we're gonna do. I'm gonna leave you in sanctions court until I can see that you can pay your probation fees on time, pay your court collection fees on time, that you can do your community service on time, and that you get back into your counseling. And you're gonna have to do that twice a month as required.
Yes, sir.
So I understand losing your job, I understand the financial issues with community service. I don't understand. Okay,
Yes, sir.
and so what we're gonna do is I'm gonna reset you to July 1st. And these are 3 things I'm gonna order you to do. You've got to pay $65 to the probation office for their supervision fees. You got to pay $40 to court collections towards your court costs and fees. You've got to work 10 hours community service. And you've got to go to counseling twice a month.
Yes, sir.
Okay, we're going to come back and we're going to talk about that on July 1st. If you don't have those things done on July 1st, then this conversation is going to go a lot different. Do you understand?
Yes, sir.
All right. So, Mr. Huggins, you've got an opportunity to keep a very serious felony criminal conviction off of your record. So I've told you before, I'm gonna tell you again, I'm gonna really urge you to take advantage of this opportunity that you have.
Yes, sir.
To screw this up and end up in prison as a convicted felon with ag rob, looking at 5 to 99 or life would be really, really sad and disappointing.
Yes, sir.
All right, sign your notice of appearance and you're free to go.
So thank you very much.
Jerry Don Brown. This is cause number CR 25-31. Mr. Brown, we reset you today for 2 purposes. One's arraignment and one is for you to have time to hire an attorney. Did you hire an attorney?
Yes, I've been talking with one.
No, my question is, did you hire an attorney? Not whether or not you were talking.
Yes, yes.
You did. So where's your attorney at if you hired?
I told him I have to, come up with the money to pay him want me to give him half which I don't have right now.
So Mr. Brown, what you're telling me is you've not hired an attorney, meaning you've not entered into a contract and given this attorney money and they've given you a letter saying, I represent you. None of that's happened, right?
No, I just talked to him over the phone and done some paperwork for him
Okay.
and told him I need time to get the money to come up with it.
How long did I give you to come up with the money?
How long did you give me? I was here, about a month? So,
And how close did you come to coming up with all the money?
not too close. I mean, it's been rough. I've been having bad luck. I'm a truck driver and the last,
I don't, my question is how much money did you save up? How much money?
I haven't saved up anything. I said, it's been a little rough. I just started back to work, for 3 weeks ago. And I had 2 trucks break down on me. So when I don't run, I don't get no check. So, it just, my luck's been running pretty bad. Yeah.
So you don't have any money today to hire an attorney? Zero.
I have nothing. I mean, I said, I've been off a whole week last week because the truck been broke down.
So I'm supposed to wait
No, I'm not saying you're supposed to wait.
Hang on, let me tell you what it sounds like to me. That you come in here, I tell you, you've got to hire an attorney, 'cause you don't qualify for court-appointed attorney. I give you time to hire an attorney. You don't save up a red cent to pay to an attorney. Go talk to an attorney. You tell me that you hired the attorney when you haven't hired the attorney. People aren't gonna work for free. And then today you tell me what it sounds like to me is I'm just supposed to wait until you decide that you're gonna work and you're gonna get money and you're gonna do these things. So you want me to just put this aggravated assault, deadly weapon, you may just put this on hold permanently for you so that you can get your personal life taken care of? And then I can let the state and the alleged victim and everybody know that we'll just go when you're ready? Is that what you want me to do?
No, sir, that's not what I'm saying.
Do you understand the importance of what we're doing here today in court? Do you understand that you've been indicted with a second-degree felony and you're looking at possible confinement in prison from 2 years up to 20 years? You understand that?
Yes.
This should be priority number one in your life because you're not going to drive a truck if you're sitting in a prison cell. You understand that?
Yes. But Your Honor, as I said, I've been going through bad time because I can't pay something that I don't have. I mean, I have to have money to give to the attorney.
Do you have trucks that you can sell to get money?
They're not my truck.
Do you have assets that you can sell to get money? Do you own things that you can sell?
The stuff that I have, I've been pawning stuff. I really don't have too much of anything.
You don't have any assets left that you can sell to get money?
Not like that, no. No, I don't. I really don't.
So what am I supposed to do with you, Mr. Brown? I'm not gonna give you 30 more days because I gave you 30 days and you did 0 with it. Maybe the best thing to do is to find your bond insufficient, put you in jail. I'll let you sit there for a little while. Then I know that you don't have money, and then I know you become indigent, and then I appoint you a court-appointed attorney, and you just sit in jail until we go to trial.
Your Honor, I've been doing everything that they asked me to do. I said, I just don't have the money that I'm trying to work, do whatever I can to pay for what I need to. The month that you gave me, I just started work. Okay, I ain't got nothing but 2 checks so far. And I hadn't even got $1,000 yet off of those 2 checks. The truck that I'm in now is in the shop now. They trying to get it to the shop so they can have it fixed. Cause I'd have to go to work. I can't pay for nothing if I don't work and get checks.
Why don't you go work for a company that has trucks that are operational and can drive today and tomorrow? Why are you working for a company that the trucks don't work and you're just waiting to get on the road? That makes no sense to me.
The truck that they sent me to get, they flew me to Memphis last week, a week before. I picked the truck up. Okay, I'm on the load to here. That they sent me Friday to go pick up in Grand Prairie. That truck broke down on me Friday. I said I didn't know the truck was like that. They didn't know the truck was like that. I mean, I had 2 trucks break down on me back to back and 1 week after another.
So you can't work again until that truck is fixed?
Yeah, they trying to put it in the shop today. We were trying to get it fixed over the weekend, but them people said it'd have to go to a dealer.
So can you go get a job with another company that has trucks that do work?
Yes, I can.
No, don't you think you should be trying to do that? Shouldn't you be saying to yourself, Mr. Brown, you know what? I've got this felony accusation against me in Van Zandt. That judge has given me 30 days to get a lawyer. I didn't get a lawyer. I need to figure out how to make ends meet. And one of these ends is, how do I satisfy this court? And you know what? I'm not going to sit around and let some employer whose truck is broken down decide whether or not you end up back in jail on Tuesday, being today.
I understand what you're saying, Your Honor.
I don't know that you do understand, because I think if you did, you would have come in and you would have told me all that. And you would have told me, hey, I've already got another job. I'm going to be working. I'm doing what I can.
I'm doing what I can right now. I really am.
You're not, Mr. Brown, because I'm sitting here telling you, go get another job.
Okay, I understand.
I don't think you do. You don't understand. I'm having to tell you what to do with your life to get money. You're just gonna sit back and let people decide whether or not you go to jail is what it sounds like to me. You're letting your future be in the hands of someone else, and you're not taking any initiative or responsibility for doing what you're supposed to be doing.
Your Honor, I am really trying. I'm trying. I mean, I can't make people hire me. Been filling out application. These people the first one that gave me a chance. And so I jumped on it. You know, I kind of hate I did, but I mean, I tried. I've been with them for 3 weeks. And I said 2 trucks and broke down. And so this truck now, they trying to get it fixed. I told them yesterday, I talked to them this morning on my way here. I cannot be sitting at home. I do need checks. And I mean, I talked to this lawyer. He told me how much to give him to come up with for a half down payment for him to represent me.
You have a what? You have a down payment, what?
I said, he was telling me just give him half a down note for what he charged him. I told him, okay, I need time to come up with the money. And I said, it's just been week after week. I just been bad times, just back to back. I'm not trying to get over nobody. I'm not trying to, I know you gave me a month, and I'm trying to do it all I can. You know,
This is the bottom line, Mr. Brown. I'm gonna reset you today, one last time, July 1st. You come back without a lawyer on July 1st, just plan on staying with me from there on out until we try your case.
I just need a little more time to come up with the money so I can give them. I mean, that's all I'm asking.
Well, I just told you I'm giving it to you.
Okay, I appreciate
But
it.
you gotta listen to what I said. I'm gonna reset you to July 1st. And, cause I don't think you were listening. I'll say it again. I'm gonna reset you to July 1st.
Okay.
To give you time to hire an attorney.
Mhm.
You come back without an attorney, plan on staying with me until we resolve your case in a trial, which could be months. Plan on it.
Okay, I understand. Your Honor, I am trying. I am really trying.
So right now, Mr. Brown, that's just what you tell me and it means nothing to me. I'd rather you show me.
Okay.
Show me on July 1st. You show me on July 1st and
Mhm.
we'll hit the reset button.
Okay, all right.
Mr. White, are you ready? Anyone, or do you need time?
I'm ready to go.
Who would you like first, Mr. White?
Mr. Kinsey.
Arnold Ray Kinsey, CR 25-59, come on up. All right, Mr. Kinsey, set for pretrial today.
Your Honor, we filed a motion to suppress. It shouldn't take very long. If we end up having one, so.
All right, we don't have an evidentiary setting in June, but we do have it on July 3rd. So we'll set motion to suppress for hearing on July 3rd. At 9 a.m. Mr. White, has Mr. Kinsey signed his conditions of pretrial release?
No, sir. he has not.
All right, if you'll go have a seat in the hallway, Ms. Burns, can you have Mr. West make sure that he sees Mr. Kinsey so that Mr. Kinsey will sign up? Just go ahead and have a seat in the hallway and they'll be with you. Once you sign, you're free to go. Who'd you like next?
Mr. Blue.
Did you say Baloo?
Zachary Blue.
I don't have a Mr. Baloo.
I mean, I'm sorry.
All right, Mr. Cooley. Come on up. This is cause number CR 25-72, State of Texas versus Zachary Blue Cooley. We're set for pretrial. Go ahead, Mr. White.
Your Honor, we're set for pretrial. We don't have any contested motions. We'll abide by the court's pretrial order and ask the court to move this over to docket call.
All right, court sets Mr. Cooley for docket call. We'll set on July 1st. 9 a.m. Has Mr. Cooley signed his conditions of pretrial release? Have you met with Mr. West?
Yes, sir.
Okay. All right, then, once you get your notice, you're free to go. Anyone else at this time, Mr. White?
Not.
Okay. Mr. Gray, if you'll come forward. This is cause number CR 24-99, State of Texas versus Ian Perry Gray. Mr. Gray was set for docket call today. Ms. Brumbelow has contacted the court, indicated that she is ill and filed a motion for continuance. Was that e-file today? That was e-file today, Mr. Hernandez. So the court hasn't reviewed it, but the court will grant Ms. Brumbelow's motion due to illness. Mr. Gray has appeared. We will reset this for docket call. June 12th. So it's a couple weeks. So, Mr. Gray, we're going to bring you the notice of setting. If you'll just sign that, then you're free to go. And we'll notify Ms. Brumbelow of the next court date.
Okay, thank you.
Ms. Kirby. This is cause number CR 25-49, State of Texas versus Karen Marie Kirby. She is set for pretrial today. Mr. Weiner has filed a motion for continuance. Court's granting that. Mr. Weiner is in trial in Navarro County. The court is going to reset Ms. Kirby to June 12th for pretrial. Ms. Kirby, have you signed the court's conditions of pretrial release? Have you met with Mr. West before?
No.
You haven't? Okay, we'll need to do that today. So you'll sign this notice of setting. And then after that, we'll meet with Mr. West. Is Larry Stanford here? All right, are you Mr. Eisenberg?
Yes, Judge, I am. Thank you for discerning me.
Well, I was down to one final attorney and I didn't recognize you, so I was like, process of elimination.
Okay, and so we have.
This is Mr.
Cunningham.
Daniel, Jonathan Daniel.
Yes.
This is cause number CR 25-38, State of Texas versus Jonathan Daniel, and we are set for pretrial today. Any announcements?
Well, we have, we believe we have most of the discovery, on the video that we had. There's some missing audio. We don't know whether that's a defect or whether it's recoverable. And I've just spoken with, I'm sorry, I don't know the assistant.
Mr. Hernandez and Mr. Hartwell.
I spoke with Chris Hartwell, and he suggested that we tell you we got most of the discovery, and that we would like to sit and confer with them. So we need to set up a time, because we're prepared to do that today, but apparently they're not. So if we can just pass it for another setting, another, I guess, pretrial, potentially, if we can't work something out, we anticipate a motion to suppress.
All right, so I will set this. Any objections from the state?
No objection to an additional pretrial, Your Honor.
All right, we'll set this to July 1st. And prior to July 1st, if you need to file a motion to suppress, that needs to be filed 7 days prior to that. And then on July 1st, we would not hear the motion to suppress. We would set it for hearing later in the month or in August.
Does that give us, Your Honor, does that give us enough time to try and schedule something, visit with y'all?
It's more than 30 days, so it should be. Any issues?
It shouldn't be an issue, Your Honor, to at least, if we can't schedule an in-person meeting, at least have a phone call to discuss whatever issues there are.
Okay, all right, court sets this case for July 1st at 9 AM, and once he signs, he's free to go. Do you know if your client has signed his court's conditions of pretrial release? He has?
Yes, sir.
Okay, all right, very well. All right, then Mr. Daniel's free to go.
If you just send me an
Hernandez. Yes, sir. Pleasure to meet you. Thank you.
Yes, sir. You ready, sir?
Alphabetically, I guess, Daniel Admire.
Mr. Admire, you'll come forward, sir. This is cause numbers CR 24-250 and 251, State versus Daniel Jack Admire for docket call.
Judge, we're gonna ask for a final docket call setting, see if we can't resolve it.
The objections from state.
No, Your Honor, thank you very much.
All right, court will set Mr. Admire for docket call. Tuesday, July 1st.
Yes, sir.
Court sets Mr. Admire for final docket call July 1st at 9 a.m.
Bennett.
Ms. Bennett. This is cause number CR 25-4, State of Texas versus Linda Diane Bennett. Set for docket call.
Judge, could I get, July 1st, another docket call?
Any objections from state?
No objection, Your Honor.
There being no objections, court sets Ms. Bennett for final docket call July 1st, 9 a.m.
Roger Bridges.
Bridges. Clause number CR 24-299, State versus Roger Neal Bridges for docket call.
Judge, I think we're pretty close, and Mr. Bridges will ask for an additional docket call.
Before we do that, I see that Mr. Bridges has got some pretrial concerns. I noticed that he failed to report, I believe in April, is delinquent on his bond supervision and attorney fees. You want to talk with your client about that? While they're doing that, is there any objection from the state on his request for an additional docket call and final docket call?
No objection, Your Honor. Thank you.
I think he's met with Mr. West here today, and I don't know about the April date. I think he's delinquent in his fees as well, Judge. I think he can commit to $50 by the end of the week, pay towards that delinquency.
So what we'll do, Mr. Schmidt, I will reset Mr. Bridges for docket call July 1st at 9 a.m. But I am going to drug test Mr. Bridges today.
Yes, sir.
If he's positive for anything that's a violation, then he's going to stay with me.
That's good.
So Mr. Bridges, after you talk with Mr. Schmidt, come over here and have a seat.
Mr. Coleman, I think she on Zoom, Judge.
Yes, yes. Good morning, Ms. Coleman. Can you see and hear me okay?
Yes, I can. Good morning.
Good morning. Can you see your attorney, Mr. Schmidt, also? If you can't, you may have to swipe left or right on your phone. All right, so when you did that, I think it muted.
Okay.
Okay, can you see him? He's in the courtroom. You see him
Yes, I
waiting?
see him. Yes, I see him.
All right, Ms.
Thank
Coleman,
you.
you're welcome. I'm gonna call your case. This is cause number CR 25-35, State of Texas versus Carissa Bernice Coleman. We're set for pretrial. Record reflects that Ms. Coleman is appearing via Zoom today with the court's permission, and we're set for pretrial. Go ahead, Mr. Schmidt.
That's correct, Judge. At this time, we don't have contested pretrial motions that need a hearing. We'd ask for docket call setting.
All right, court finds there are no contested pretrial motions. Court sets Ms. Coleman for docket call on July 1st at 9 a.m. So Ms. Coleman, you're reset to July 1st, and we'll see
Okay.
court on that day, okay?
Is this in person or in Zoom?
In person.
Okay. All right.
All right, and so stay in contact with your attorney, Mr. Schmidt.
All right. Thank you.
You're free to go.
Thank you.
Who's next, Mr. Schmidt?
Fernando Hernandez.
Mr. Hernandez? Cause number CR 23-162, State of Texas versus Fernando David Hernandez for docket call.
Judge, I think we're announcing ready for trial today.
Okay. And what is the offer that the state has made that the defense is rejecting?
5 years TDC.
5 years TDC. All right, and your client understands that there may not be any plea negotiating after this date.
Yes, sir.
All right, court places Mr. Hernandez on the court's trial docket. Mr. Hernandez is ordered to report back to the court on Monday, June 23rd.
Benjamin Carnes.
Mr. Carnes? Carnes?
Maybe he didn't show up yet.
Oh yeah, he was at night, so I didn't, well, maybe you had him here.
Moreno.
Mr. Moreno? This is cause number CR 24-242, State of Texas versus Reno, Santana, Moreno for docket call.
Judge, I'm gonna ask for an additional docket call. We're trying to secure some evidence. Not quite there yet, but ask for that July 1st date.
No objection, Your Honor. Thank you.
All right, there being no objection, court sets Mr. Moreno for docket call July 1st. 9 a.m.
Stephen Richardson.
Mr. Richardson? This cause numbers CR 25-12 and 2024-219, State of Texas versus Stephen Ray Richardson.
Can I get just 1 second?
Yes, go ahead.
Judge, we'd ask to set Mr. Richardson for a plea by July 1st.
Were we not set for plea today?
No, sir?
No.
I anticipated, hopefully, and I think I might have put it on the list, but we were set for docket call today. Should be.
Afternoon plea or morning plea?
Morning plea, please.
Any objection from the state?
No, Your Honor, thank you.
All right, court sets Mr. Richardson for plea on July 1st. If we don't have a plea that day, then that'll be the last setting.
Yes, sir. Now approach, Judge.
Yes, sir. Yes, there is. Is he in the court? Is he in the court?
He's coming in. I think he's sitting up.
All right, this is cause number CR 25-20, State of Texas versus Pascal Todd Waters for pretrial. Go ahead.
Judge, at this point, we have no contested pretrial issues to bring to the court. I do believe that I filed a motion to transfer a county court law companion case up here. I'm not sure if the court has received that yet, but I want to just bring that to your attention. He's got business there. I was trying to get it all up here, but other for this case, we'll ask for a docket call setting.
All right, I haven't seen any motions to transfer, and I'm up to date on whatever's been filed, so.
I'll double check with Mr.
All right, court sets Mr. Waters for docket call hearing July 1st at 9 a.m. Mr. Waters. Court starts at what time? Court starts at what time?
He's asking me what time does court start?
9 o'clock.
And what did we wear to court?
I was, sitting in cricket. I was gonna get my phone fixed. I didn't know I had court today. I apologize, sir. I'll be in jean or pants separate for court next time. I promise, sir.
Thank you, sir.
I'm ready on Ms. Holleshauser.
Ashley Holzhauser. This is cause numbers CR 24. CR 24-263, 264, 265, 266, 267. Is this a plea today?
It is, yes, sir. We should have two sets of plea papers. One of those sets contains.
All right, Ms. Holzhauser, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you can lower your hand. All right, Mr. Schmidt, so she is taking a plea on cause number CR 24-265, is that correct?
Yes, sir. It's the criminal mischief, second degree.
And then also CR 24-266,
That's correct. Should be, that precious metal.
and then all the remainder will be 1245.
Yes, sir.
All right, Ms. Holzhauser, in cause number CR 24-265, you are charged by indictment with a second degree felony offense of criminal mischief greater than $150,000, less than $300,000. Ms. Holzhauser, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done as your attorney?
Yes, sir.
Do you have any questions about the plea paperwork or anything that you've read and signed in this case?
No, sir.
Mr. Schmidt, do you believe Ms. Holzhauser to be competent to enter into an agreement? And if so, you believe that she's entering into this intentionally, knowingly, and voluntarily? And also that she's doing so after she is fully aware of the advantages and disadvantages of a deferred adjudication plea?
Yes, sir.
All right, Ms. Holzhauser, in that cause number CR 24-265 on the charge of criminal mischief greater than $150,000, less than $300,000. That is a second degree felony that does carry a range of punishment of not less than 2 years in prison and up to a maximum of 20 years in prison should you be convicted and sentenced. I see that there's a plea agreement in this case. Upon your plea of guilt, states are recommending that the court consider the evidence, defer a finding of guilt, not convict you today, placing you on community supervision for 10 years. In addition, you would be responsible for court costs and reimbursement fees. In cause number CR 24-266, you've been indicted with a third degree felony offense of theft of precious metals, less than $20,000. Third degree felony has a different range of punishment. It's not less than 2 years in prison and not more than 10 years in prison should you be convicted and sentenced. In the plea agreement, upon your plea of guilt, the state's recommending that the court also consider the evidence, not convict you, placing you on deferred community supervision for 10 years. And the state is dismissing and considering and asking the court to dispose of several charges. One of those being an unfiled theft of property less than $2,500, and indicted engaging in organized criminal activity, indicted criminal trespass of a habitation, shelter, or superfund infrastructure, cause number CR 24-267, and indicted burglary of a building. And all of your agreements would run concurrent with one another. You would also be responsible in this case for court costs and reimbursement fees, including your attorney fees. Ms. Holzhauser, is that your understanding of the plea agreement, what you're asking the court to approve?
Just 1 second, Judge. You said what?
It was before.
It's a habitation. It's on some side, super fun side. So it's the one. Okay.
Yes, Your Honor.
Does she have any questions, Mr. Schmidt? that the court
Yeah,
needs to
Judge,
address?
it's the nature of the compound nature of the charge that includes Superfund side. She was confused by that.
Okay. And just because I haven't considered the evidence, I don't know what it is.
Yes,
I haven't looked at it yet, so. All right, so understanding the plea agreement, understanding the range of punishment, Ms. Holshouser, how do you plead to criminal mischief greater than $150,000, less than $300,000?
Guilty.
How do you plead to theft of material known as precious metal, also aluminum, bronze, copper, or brass, less than $20,000 in value?
Guilty.
Are you pleading guilty to each one of these crimes because you are in fact guilty of committing each crime?
Yes, sir.
Ms. Holshouser, has anybody threatened you, forced you, pressured you to plead guilty to either crime?
No, sir.
Court does accept the defendant's plea of guilt to each crime. Respectively, the court will take judicial notice of the defendant's judicial confession. Mr. Schmidt, any objection to the stipulation of evidence being admitted? That is admitted, and the court's already taken judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that there are a couple of co-defendants in this case that have already pled out. As far as restitution goes, there was a general estimate for the repair bill. However, when the state reached out to get a more itemized amount for repairs, it was not returned, which is why there's no restitution requested in the case.
Thank you, Mr. Harwell. Anything further from the defense?
No, sir.
All right, court will consider the evidence. The court, having considered the evidence in each case, finds enough evidence to convict the defendant of each crime. Court will follow the plea agreement recommendation of the DA's office. Court hereby defers a finding of guilt on the second-degree felony offense of criminal mischief greater than $150,000, less than $300,000. Court places Ms. Holshouser on 10 years community supervision. Orders that this sentence in this case run concurrent with cause number CR 24266. Orders her to pay court costs of $290 and reimbursement fees of $35. Cause number CR 24266. The court also defers a finding of guilt, places Ms. Holshouser on deferred community supervision for a period of 10 years on the charge of theft of material containing aluminum, bronze, copper, or brass less than $20,000 in value. Court does take into consideration and disposes today unfiled theft of property less than $2,500 or two or more previous convictions, indicted engaging organized criminal activity, CR 24264, indicted criminal trespass, habitation, shelter, or superfund, cause number CR 24263, burglary, indicted burglary of a building, cause number CR 24-267. The court runs this sentence to orders this case to run concurrent with the sentence in cause number CR 24265. In addition, the court orders Ms. Holshouser to pay court costs $290 and reimbursement fees of $535. Ms. Holshouser, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted. After that, you'll meet with the probation officers.
Yes, sir.
Right, who you ready on?
Mr. Huffman.
Joshua Huffman, it's cause number CR 24-165, set for docket call. Go ahead, Mr. White.
Your Honor, I was talking with Mr. Hernandez about this. I think the state is gonna join me. We're gonna ask for one final docket call. If we can't come to an agreement by that point, we'll just have to put it on the trial docket.
Any objections?
No, Your Honor, thank you.
All right, can we set this, when do you want, Mr. White? I showed that we were set for final docket call today, so I was kind of expecting some kind of,
I understand, Your Honor.
so I'd rather not set it much longer. What date are you looking for?
If July 1st is okay, Your Honor, I think.
All right, court sets Mr. Huffman for docket call July 1st. That'll be the last setting. It'll either be agreement or we'll set for trial.
Thank you, sir.
Mr. Brown, Your Honor.
Joshua Neal Brown. Cause number CR 24-255.
Your Honor, we're in the same situation on this. We're gonna ask the court for one more chance to work it out. If we can't, we'll set it for trial.
State.
Okay, Your Honor, thank you.
All right, court sets Mr. Brown for final docket call July 1st.
Mr. Swallows.
Mr. Swallows. Cause number CR 25-16, State of Texas versus Philip Wayne Swallows. Set for pretrial.
Your Honor, we don't have any contested matters. We'll ask the court to move this over to docket call.
Court sets Mr. Swallows for docket call July 1st, 9 a.m. Swallows. So court starts at 9 o'clock. Why were you not here till 10 o'clock?
I flew in from Chicago. I lost my job because I had to be here. And it's been quite a challenging trip.
Okay. I want you to meet with pretrial release before you leave. Okay. You need some more time? Mr. Schmidt, who are you ready on?
Rodenball. Rodenball.
Michael Lance Rodenball, cause number CR 25-55. We're set for pretrial today.
No contested pretrial motions. Judge asked for a docket call, sir.
All right, court sets Mr. Rodenball for docket call July 1st at 9 a.m. Mr. Rodenball, have you signed your conditions of pretrial release?
Yes, a while ago. Yes, sir.
Good job. All right. Once you sign this notice and get it, you're free to go.
Thank you. Thank you. Yep.
Oh, you, sir. We go get that. Somebody left their phone. Here. Who would you like next?
Courtney Atwood.
Courtney Atwood. Right, this is cause numbers CR 24-196 and 197, State versus Courtney Joe Atwood. Ms. Atwood, you'll raise your right hand. I'm gonna place you on oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you can lower your hand. All right, Mr. Schmidt, is she entering a plea to clause number CR 24-196?
Yes, sir.
And will it be a 1245 on 197, or does she have a separate plea?
It should be a 12:45.
1245. Schmidt, do you remember seeing and signing a 1245?
Now it's mentioning I do not,
Not finding.
because I only had one set. I don't think it was actually in that,
I don't.
that packet. Yeah.
I see it referenced in the plea agreement on the judgment, but I just don't see the actual 1245 document, so
Your Honor, I can print a new one off.
you do. All right, Ms. Atwood, in cause number CR 24-196, you're charged by indictment with a action charge. Is she charged by indictment with a class B misdemeanor? Or is that a lesser?
I believe it was run through the grand jury. I don't think that there was an information file. It was filed with your court originally.
And Your Honor, that's correct. It was indicted along with the other case.
Okay. Ms. Atwood, you're charged with a class B misdemeanor offense of driving while intoxicated with an open container of alcohol. A class B misdemeanor does carry a range of punishment up to a maximum 180 days confinement in the county jail and a fine not to exceed $2,000. I see that the plea agreement in your case is that upon your plea of guilty, the state's recommending that the court consider the evidence, assess your punishment. Well, this says punishment at 1 year in the county jail, probated for 2. That'd be an illegal sentence. It's a class B misdemeanor. It'd be a maximum of 180 days. Is the degree incorrect? This should be class A misdemeanor.
Your Honor, I believe the amount of days is incorrect. It is a class B misdemeanor. It should read 180 days.
Okay. All right. So let's get that corrected and we'll go ahead and have a seat and we'll call you back up. You ask Ms. Abney to redo those.
Yes, sir.
All right, court's gonna stand in recess for 20 minutes. So my court reporter can take a break. All right, court will set Mr. Vasquez then for docket call July 1st. Mr. Schmidt, Mr. Vasquez was late today, no?
Yes, sir. He was late.
You talked to Mr. Vasquez about that?
Yes, sir. It was an error on his part. May we approach the bench?
You may. Mr. Vasquez is going back to court July 1st. Is that what you're comfortable with? Back on record, call number 024-196-024-197. State versus Courtney Joe Atwood. Miss Atwood, you understand you're still under oath?
Yes, sir.
Okay. All right, so we last left off, I was explaining to you some of the legal facets of your case, and so let's kind of go back into that. You are charged with a Class B misdemeanor offense of driving while intoxicated with an open container of alcohol. A Class B misdemeanor does have a range of punishment up to a maximum 180 days or 6 months confinement in the county jail and a possible fine not to exceed $2,000. The plea agreement in your case today appears to be upon your plea of guilty. State's recommending that the court consider the evidence, accept your plea, convict you of the offense, assess your punishment at 6 months confinement in the county jail for 180 days. But the state is asking the court to suspend that sentence and place you on community supervision or probation for a period of 2 years. They're also recommending a $1,500 fine, a $3,000 DWI traffic fine, which they're recommending to be suspended also would only apply if you were revoked and your conviction becomes final. In addition, you would be responsible for court costs of $270, restitution of $180, and reimbursement fees of $550. The state is agreeing to resolve and dispose of your indicted felony, CR 24-197, which is a possession of controlled substance. Ms. Atwood, is that your understanding of the plea agreement?
Yes, sir.
All right, and You are a United States citizen who reads, writes, and speaks English. Is that correct?
Yes, sir.
Have you ever been diagnosed with a mental condition?
Yes, sir.
And what is that?
It was, when I was a child, bipolar and depression.
Okay. Are you currently on treatment or any type of medication for that?
No, sir, I'm working on to get back on medication.
Okay. Do you feel like, Ms. Atwood, that there's any, do you feel like there's any kind of misunderstanding due to your mental health condition that it's causing you difficulty to understand the proceedings, what's going on, what my role is, what Mr. Schmidt's role is, what the prosecutor's role is?
No, sir.
You understand all of those things?
Yes, sir.
Mr. Schmidt, do you believe your client to be competent? Have you seen any evidence that she has any mental health issues that could make this plea involuntary? And if not, that she's entering into this plea intentionally, knowingly, and voluntarily?
Judge, I've seen no evidence that would lead me to believe that she was incompetent, and so I'm comfortable proceeding.
Okay, and you've explained to her rights regarding the case?
Yes, sir.
You believe that she understands them?
Yes, sir.
All right, Ms. Atwood, at this time, how do you plead to driving while intoxicated with an open container of alcohol?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
Court does accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
Stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, the court's going to consider the evidence. Right, the court, having considered the evidence, finds enough evidence to convict the defendant of the offense. The court will follow the plea agreement today. Court hereby convicts the defendant of driving while intoxicated, a Class B misdemeanor with an open container of alcohol. Court assesses punishment at 6 months confinement in the Van Zandt County Jail. The court suspends that sentence today, places Ms. Atwood on 2 years community supervision. The court assesses a fine in the amount of $1,500 and a DWI traffic fine in the amount of $3,000. The $3,000 DWI traffic fine is probated and only applies if the defendant is unsuccessful and has her community supervision revoked. The court also assesses restitution in the amount of $180, court costs in the amount of $270, and orders Ms. Atwood to reimburse Van Zandt County $550 for fees and services rendered on her behalf. Ms. Atwood, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you come forward to be fingerprinted with Deputy Martinez. After that, you'll meet with probation. I do have one quick question now. So on the fee, just because I don't do a lot of these DWI misdemeanor, DWI traffic fines. So the way that the plea agreement reads, it says that there's 2 fines, but it's not real clear to me on which fine is probated, because the fines say $4,500 and then the plea agreement says $3,000 traffic fine is probated. So does that mean the $1,500 fine is not probated?
Correct, Your Honor.
All right. Any questions about that?
No, sir.
Okay. All right. Come on up to be fingerprinted. Mr. White, who are you ready on?
Ms. King.
Ms. King, you'll come forward. This is cause number CR 24-278, State of Texas versus Kimberly Madeline King. Is this a plea today, Mr. White?
Yes, sir, it is.
Ms. King, if you'll raise your right hand, I'm gonna place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Speak up. All right, you gotta speak up so I can hear.
Yes,
All right, you can lower your hand. All right, Ms. King, are you a United States citizen who reads, writes, and speaks English?
yes,
Have you ever been diagnosed with a mental condition?
yes,
Say again.
yes,
And are you currently on treatment or medication for that? Do you feel like your mental health condition is any way impeding your ability to understand what's going on in court
no,
today? In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White and the work he's done as your
Yes.
attorney? And you gotta let me finish the question
oh,
for two reasons. One, you gotta know what I'm asking before you try to answer.
Zach,
Hang on. And two, she's gotta write it down. If you're talking at the same time I'm talking, she can't write them down, okay? I know you may be a little bit nervous, but let me finish, okay?
3-second pause.
So, Ms. King, you're pleased with Mr. White and the work he's done as your attorney. Do you have any questions about any of the paperwork that you've read and signed over today?
No, sir.
Okay. Mr. White, do you believe Ms. King to be competent to enter into this plea agreement?
Yes, sir, I do.
Do you believe that she's entering into this intentionally, knowingly, and voluntarily?
I do.
All right, Ms. King, you are charged by indictment with aggravated assault with a deadly weapon. I see today, though, that the plea agreement and recommendation is for you to plead to a lesser included offense of deadly conduct, discharge of a firearm. That being a third-degree felony offense, which carries a range of punishment of not less than 2 years in prison up to a maximum 10 years in prison, and carries a possible fine not to exceed $10,000. I see that the plea agreement is upon you pleading guilty, your punishment would be assessed today at 2 years confinement in prison, with that sentence being suspended and you being placed on community supervision for a period of 5 years. In addition, you would be assessed a fine of $1,000, court cost of $290, and reimbursement fees of $35. In addition, to the plea, you would be placed on the mental health caseload as a condition of your community supervision. Ms. King, is that what your understanding of the plea agreement is?
Yes, sir.
All right, understanding all of those things, Ms. King, how do you plead to deadly conduct, discharge of a firearm, a lesser included offense? Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
I'm pleading guilty because I think it's best that I do.
You understand, Ms. King, that's not a plea that this court
Okay.
can accept. So I want you to,
Fine.
well, I want you to take a moment, just step over with Mr. White. And I want you to talk with him, ask him any questions about this, but the court has to know whether or not you're admitting guilt to it or not. If you're not, and you just want to do it because that's what you think is best, the court's not going to be able to accept that as a plea. Okay? So
I'll plead guilty.
then I have to ask you, are you pleading guilty because you are guilty of committing this offense, a deadly conduct by discharging a firearm? Did you commit that conduct?
Yes, sir.
All right, court accepts the, well, let me ask you, Ms. King, has anybody threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, the court will accept the defendant's plea of guilt at this time. Mr. White, any objection to the stipulation of evidence?
No objection.
Stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, thank you.
Any victim stance on this?
The state is in compliance, Your Honor. The victim impact statement was provided. No return was received.
Thank you, Mr. Hernandez. Anything further from the defense? All right, court will review the evidence. All right, the court having considered the evidence, finds enough evidence to convict the defendant of this offense, the court will follow the plea agreement and recommendation of the DA's office. Court hereby convicts Kimberly Madeline King of the lesser included offense of third-degree felony deadly conduct by discharge of a firearm. Court assesses punishment at 2 years confinement in prison. Court suspends that sentence today and places Ms. King on 5 years community supervision. Orders her to pay a $1,000 fine. Court places her on the mental health caseload. Also orders her to pay court costs of $290 and reimbursement fees of $35. Ms. King, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with the deputy. After that, you'll meet with the probation department.
Where?
That's right. Anyone else?
Mr. Brandon, I believe state has a motion on that. End of the court.
Mr. Brandon, come on up. This is cause number CR 21-206, state of Texas versus Lemmy Brandon. Good, Mr. Hernandez.
Motion to dismiss, if I may approach.
You may. All right, the court finding that the state has tendered a motion to dismiss, court hereby grants the state's motion and is signing the order dismissing the case today. All right, Mr. Brandon, you're free to go. Right, if you need a copy of that, once it's filed with the clerk's office, we'll get it to you. Here, you can let Nolan walk over there. You're welcome.
We have Mr. Bond.
Mr. Fontenot, this is cause number CR 24-258, state of Texas versus James Owens Fontenot. All right, I believe we're here today on docket call and also an issue with the pretrial intervention. Let's take up the docket call.
Your Honor, because of the new offense, we're gonna withhold announcement. I haven't seen anything from the state on that new offense. I do know it doesn't have anything to do with the case that he's currently on bond on. Has to do with a wreck and then no insurance and some other things. Doesn't involve intoxication either.
Hernandez.
Your Honor, that's probably the update that I would have had also. It is a traffic matter. So we're looking at to obtain as many of those reports or maybe even the entire case to hopefully move the whole thing forward.
And so my understanding, it's a driving while license invalid without insurance. My report says collision causes serious bodily injury or death. Was death a result of this accident?
No, sir.
No, just serious bodily injury or what they
What they
alleged?
yes, sir. I don't know what the injuries were. I do know they were transported, but that could have been for caution. I don't have.
All right, Mr. Hernandez, do you want to be heard on the pretrial release issue at all?
No, Your Honor, actually, I think this is the first I've heard of it. I was not up to speed on that. My apologies.
Mr. Wright, will you approach Mr. Hernandez? All right, board is going to reset Mr. Moreno for Rodenball on July 3rd. Be on towards evidentiary docket. Also on that day, board will reconsider as well, based on information that's been provided to the board. The board will ensure that this is provided also to the defense since they not already received it. I believe that on May 5th, it was emailed to Mr. White. So I believe the state responded of it. So at this time, based on the information provided, the board believes that Mr. Moreno has violated the terms and conditions of his pretrial release. The board is going to find his bail posted at this time to be insufficient. We'll take Mr. Moreno into custody. We will revisit this bail on July 3rd, unless he posts a new bail between now and that.
And to be clear for the record, that has to do as the court's discretion with a new charge, the court can increase bail per statute.
That's correct.
Flight with. No. Mr. Schmidt, are you ready?
All right, Mr. Bridges, you can just stay where you're at right there. This is cause number CR 24-289, State of Texas versus Roger Neal Bridges. We're back on record. Mr. West, as the pretrial release officer, the court requested that Mr. Bridges be tested for compliance with the court's pretrial release conditions. Did you conduct a urinalysis, a test of Mr. Bridges?
Yes,
All right, and what were the results of that test?
he was positive for marijuana. And he did an admittance to marijuana, but he was also positive for methamphetamine, which we're sending to the lab because he didn't admit to that.
So THC and methamphetamine, he admitted to the THC marijuana, but did not admit to the methamphetamine, and that's being sent for confirmation.
Yes.
All right, Mr. Bridges, I gotta be a man of my word, and I've got to keep you here. So I'm gonna find that you have violated the conditions of your pretrial release. The court's gonna find your bail to be insufficient at this time. You're gonna take it. So just remain where you're seated. We'll have you back on July 1st. We've already said that, Mr. Schmidt. Cause number CR 24-164, State of Texas versus Shunta Foster. Ms. Foster is still in Gregg County. Any updates on that, Mr. Schmidt, to your knowledge? Okay. Any updates from the state? Are you aware of anything?
Your Honor, the last I heard, they're still waiting on a bed for Miss Foster, to see about restoration. But I haven't heard anything, concrete yet.
Okay. Court will reset Ms. Foster for another status. Let's set her further out. We'll set her August 26th. Is that fine with you, Mr. Schmidt? August 26th? Mr. Schmidt on Mr. Williams, Ray Anthony Williams, cause number CR 24-226. Board has received notification from Mr. Williams and has received documentation from Medical City Children's Hospital that Mr. Williams' son was admitted to the hospital today. Board will reset Mr. Williams' case. You're set for docket call. We'll reset for final docket call on July 1st. If you have a communication, Mr. Williams, I show that he's delinquent on his bond supervision, $70, and his attorney fees, $350. So if you'll relay that information, we'll see him back on July 1st. Court calls CR 25-8, State of Texas versus Trevor Glover. Show that we were set for a plea today, and then the court received a work release form from Baylor, Scott and White, Sunnyvale, indicating that Mr. Glover had seen the physician in that facility on, I think that's the 25th, not sure.
Judge, I met with his grandfather. Harrison this morning. He's fairly serious. So it's my understanding it's actually.
It does say, it looks like maybe May 25th to present, so maybe over the weekend, so. Court will reset Mr. Glover for July 1st for docket call. Did you have a plea worked out for Mr. Glover?
We do, Judge. Well,
We'll set this for plea and docket call July 1st. Clause number CR 24-128, State of Texas versus Wyatt Lane Berkwin. He is verified in TDC in the Kyle unit. Are we going to be bench warning Mr. Berkwin? What's the status of the state's prosecution?
Your Honor, yes, state would request a bench warrant.
and Judge, I think the reason why we haven't requested the thus far. Got it, safety.
Oh, that's right.
Was that the guy? And he was in the halfway house. In this case, it's the defendant. I think that's.
That does sound familiar.
I remember talking about him being in safety, and if that is the case, I prefer him finish his treatment before we resolve any issues.
Yeah, that's, I mean, he should be in a halfway house. This was, he was charged like a month ago. So far as I know, it's going on.
Do they still show being included in custody in a unit if they're in
Not
a
if
house?
they're in the halfway house, but there's him play there 60 to 90 days. Each time still in the college. Yeah.
Yeah, he's showing absolutely in custody. So I'll tell you what, let's reset this to July 1st. Let's figure out what the details are for Mr. Berglund. Whether there is a safety, a halfway house thing. If not, if in the meantime you find out that he's not, well, this is the wrong guy, then let's do the bench warrant. We'll get him down here. Clause number CR 24-198, State of Texas versus Trevion Lakeith Bowie. We are set for arraignment today. I show that Mr. Bowie is in custody in Smith County. either defense or state have any knowledge or information on that?
I'm afraid I don't, Your Honor.
All right, court will reset this for arraignment July 1st. All right, so we'll issue a bench warrant for Mr. Bowie, come back on July 1st. Court call CR 22-336, State of Texas versus Anthony Murray. Mr. Hernandez, I think at the last setting, you gave us some updates where you believed that Mr. Murray was going to be released from custody in Florida, I believe. Or actually, it's Pennsylvania, I think. Do you have any knowledge on that or any information?
I don't have an update on that, Your Honor. I do recall that he was finishing up his sentence and he would be available at that time, or something to the effect that he may have been maybe coming back to Texas. And that was as a result of getting a phone call from a DEA agent, if memory serves.
And the sentence that he's serving in the federal system is unrelated to
It's
our.
unrelated, Judge, it's occurred. My recollection, we received 36 months. Federal system. Yes, it's probably about a year and a half, so. It's fired. So they're bringing him to Texas. And in other words, I didn't anticipate him being released from federal custody. Quite a few more months.
All right, court will reset Mr. Murray then for status July 1st. Mr. Hernandez, if you could reach out and find out what the status custody is.
Yes, Your Honor.
Custody status, rather. Mr. Schmidt, any word on Benjamin Carnes?
No, sir.
I believe that's the remainder of your docket, is that correct? All right, we'll have Mr. Carnes' name called loudly and distinctly 3 times at the courthouse for a bond forfeiture. We'll also have the name Larry Stanford called. We communicated, did you communicate separately with Mr. Weiner's office regarding Mr. Stanford and his responsibility to be here? So what we may do on Stanford is we may just take that under advisement until Thursday, give him time to appear. His other client was here, so. Response? All right. The court has called the name Benjamin Colin Carnes. The announcement on the morning's docket, Mr. Carnes is not present at 9 a.m., is still not present at this time. His name has been called loudly and distinctly 3 times in the courthouse with no response. Court hereby issues a judgment nisi and alias capias for Benjamin Colin. Court finds that Larry Charleston Stanford was ordered to appear in court today, has failed to appear. His name has been called loudly, distinctly 3 times in the courthouse with no response. Court will take a judgment nisi and alias capias under advisement until noon on Thursday of this week, that being May 29th. We'll give Mr. Stanford an opportunity to appear as his counsel is in trial in Navarro County and did file motion for continuance that was granted by the court. Ms. Taberham, if Mr. Stanford does appear to sign his notice of reset, we need to send him over to see Mr. West because I believe he failed to report March and April and he's delinquent on his bond supervision fees. So Mr. West, if Mr. Stanford appears between now and noon on Thursday, then I'm gonna send him over to CU to address his failure to appear in March and April, so get a drug test. Yeah, we'll go ahead and set Mr. Stanford for pretrial hearing with Mr. Weiner on June 12th. Mr. Ward, is that correct? All right, Mr. Juarez, come on up. All right, Mr. Juarez, this is a sanctions court hearing, cause number CR 23-185. Looks like you paid $360 towards your probation fees. That's good. You also paid $300 towards your district court collection fees. That's good. Looks like you're still failing to work your community supervision. Is that correct?
Yes, sir. There was, I still make videos and everything. Make you. Well, since I get off every 2 weeks on Sunday, I get off pretty well on see. If I can make a video, just donating water, the homeless or something like that, or something under my mind, or if the food banks are closed on the weekends over there. I'm currently talking about the there. I want to see if there's anything else I can make videos, but
Look, give me a second. Let me consider. All right, Mr. Juarez, I'll consider that. So what I'm gonna do is, I want you to come back on July 1st.
I know I tested positive for THC. But I can offer my days off or weekend job or whatever I have to do to stay working. Everything. However you need to stay working at the company, right? And I get off every 18 days, I get a 3-day break.
I think you'll need to talk to your probation officer about that. I'm gonna have you come back on July 1st. And I want $90 to the probation department and $75 towards your fees.
And I have called this company, it's a food bank, they said that I can pay the hours, but since I don't have time to go work the hours, I'm gonna still how much is the hour. They told me to call the probation officer.
Yeah, you'll need to talk to your probation officer about that. If you want to come over here and talk to these probation officers, they can give you more information on that. But what I want is July 1st, $90 to probation, $75 to
I have to be in person.
in person. In person. Okay, you want to be on Zoom, you gotta be in compliance. You're not in compliance, so y'all need to talk to Mr. Juarez. All right, so July 1st. $90 for probation, 75 to court collections, and I'll consider your request for the videos.
If I get the community service I was done before, then like if I get caught up on all of them, man, please do the plan about it.
Get them done and then contact your probation officer and they can make that request for you.
It was 8 hours a month, correct? So it would have been from.
It would have been 10 hours a month.
10 hours, so it would have been since August, since I came to work. So then in 97, almost 10 hours a month, catch up on them.
You know, you really need to talk to your probation officer to find out what your delinquencies are. I don't know. Those are the two things I want from you on July 1st. Right, I think that does conclude court's morning criminal docket. We'll stand in recess and resume at 1:30.